The former special prosecutor, Martin Amidu, Ababetron Krata Teten, Eddie Atuja, na yeni Martin Amidu no. If there's one thing about Martin Amidu we all know, is the fact that he likes to write. Now I want us to go through Martin Amidu and Samuel Watrono. Nini na ejina jaja emse otina Abronye case no eso. Right, I want us to go through what Martin Amidu ede ababetuja na yenhwe senia obo judge no echi. I say Judge Samuel Bright Acquah is a canker on the legal profession in a judicial service in Ghana by Martin ABK Amidu. It was a judge no or ye canker na obi kasa obi ana bibi ye canker na just any pakrono I mean canker in tree no na just say Ibakrono or canker mechanism with you. Because say you are a canker to, or you are a canker on the legal professional. Oh yeah, in order to explain so everyone understands. Oh yeah, bonea will see at the end so. That's a be a pro see at the end so. You are a canker to this thing. At the end, I best say yeah, and I'm also basically no. Sana obeti asye, what asye. Inti. Or say, I did not intend to write this article, but for having read last night the ruling of one Samuel Bright Acquah, who passes as a circuit court judge and consequently a lawyer, on the role of lawyers in Ghana, the published certified copy of the ruling of the person styled His Honor Samuel Bright Acquah in the case of the Republic versus Kwame Bafo at Abronye, particularly from pages 8 to 10, of the ruling constitutes a disgrace to the legal profession and the judicial service of Ghana. The depth of research, learning, the language used, and the writing style are not only porous, but unbefitting to be part of a long, of a final year law student, to be part of a long, long essay. But outro easy. Okay, so I think he wanted to say unbefitting to be part of a long essay, because we do final year or final project no you find a long essay, right? Into a person just a judge no a judgment no send your judge no throw in some no name some judge no throw ye na kra no say you can't final year student or year law the final year project kra no on throw sebe ade a judge no Troy and actually judge no wa born basically the opposite trend judge na born I'm a final year student grano on can say more judge in kind basically that's what Martin Amidu wants to say. Also to be part of a long essay of a final year law student on the condition on which a court may grant or refuse bail to any suspect. The question that immediately came to my mind was whether Judge Samuel Bright Acquah was a fit and proper person to have been enrolled on the roll of lawyers in Ghana in the first place. How could such a person have passed through the legal education system and being called to the bar? So, person addresses up judge krano e banese no babe than a lawyer, because in some way our born basically. How did such a person become a circuit court judge in Ghana, even if he slipped through? Mr. Ramo, just give me 1 minute of your time. Let me bring to your attention this important notice. We are near to your story. So, now, article where I'm reading from Harvard University, one of the best universities in the world. Now, I'm one link a abdominal fat to a year senipa ebe wuntem. What you say? Now, oba baby sa AI or say ane a nokwari. Excess belly fat is linked to an increased risk of early death from any cause. Not to say we fuswa one ya wie bia ebetumi ekun. Enti say utumi find a way to reduce the size of your belly. Not to say obetina wi asimwache. Na me ameka se menye doctor. But first no, na mini, na menu for abobo, na mefu eye kese. and I mean mokase miamini mefu Acquah form menufu nana abobono eko enyama miensa na meyeye na saa nyama miensa no media throw book no ewo comment box ni mu. Don't worry, se wu ni makenkan kra na ya ye book no version bi a eye video a ye trace ye wo twi mu obetumi enye no nso eno ane se wo beto book ni bi na mesrel se o click link na comment box ni mu na we hu way out how to get the book. Don't worry, just WhatsApp me on 055 807 4986 055 807 4986. Shannon son se will be bia wo beka tro say eduro bi wo ho onom ebema wefu atwen bia no oboa bibi say ni ho. Some of us we've tried it didn't work. Intino yancha story ne so. The role of lawyers. Ordinary laymen are taught from elementary school about the presumption of innocence of suspects and the burden on the prosecution to prove its case beyond reasonable doubt at a fair trial before a court of law. The grounds on which a court may grant bail to suspects are well known to the general public with any basic education. It is right that bail must not be punitive or excessive. Chapter 5 of the 1992 Constitution spells out clearly the fundamental human rights and freedoms of the citizen, including the protection of personal liberty, Article 14, respect for human dignity, Article 15, equality and freedom from discrimination, Article 17, and a fair trial with a concomitant right to presumption of innocence, Article 19. One does not need a law degree to know these rights of the citizen. Or to also I will say, the first year student in the Faculty of Law pursuing studies in law is taught the basics in his first year, General Legal Systems of Ghana course, before he studies the detailed subject of criminal procedure in later years at the professional law course. One cannot ordinarily be appointed a circuit court judge without first having been enrolled on the roll of lawyers and achieved a specified number of years standing as a lawyer. Consequently, when I read the ruling of Judge Samuel Bright Acquah, I had no doubt in my mind that he is a canker on both the legal profession and the judicial service of Ghana. A lay magistrate would not be expected to write such a ruling on bail, let alone a professional magistrate, and much more a circuit court judge who has been on that bench for years. How can the legal profession and the judicial service of Ghana have someone on the bench passing for a circuit court judge who refers to books he has patently not read as authority for refusing bail in a criminal case? The Constitution of George Orwell's Animal Farm, as stated in Chapter 2 of the book, was made of 7 commandments. The original 7 commandments in George Orwell's Animal Farm did not have any commandment stating that all men are equal, but some are equal than others. Animal Farm in Chapter 2 states, inter alia, as follows. Hey, dear, Martin Amidu, or Tete Judge Nampang. I'm going to explain up to this point. But Martin Amidu aso judge the more award sitting in Nampanya sem kitwana. Your person trend is basically no dear Martin Amidu person trend is a judge who are born. Or compare judge to a fresh law student. Right? Compare judge to law students bia ano bia we law students onye wie law school mpo. Sen someone judge no try and cran say nipa chrono trust answer no, because even first year for our Musian law no ade aye tre wo mokra no judge no echo against that thing. Now in the judge ruling no okoti book be the Animal Farm. Ena Martin Amidu etre say judge no kra won read the book no, because we read the book na ko nkoti book no te say ni okoti no. Na or trade into a judge no in read the book no or ko book ni mo. Or say the 7 commandments would now be inscribed on the wall. They would form an unalterable law by which all animals on Animal Farm must live forever. The 7 commandments are written on the 3rd wall in great white letters that could be read 30 yards away. They ran, thus the 7th commandment. Whatever goes upon 2 legs is an enemy. Whatever goes upon 4 legs or has wings is a friend. No animal shall wear cloth. No animal shall sleep in a bed. No animal shall drink alcohol. No animal shall kill any other animal. All animals are equal. So say chapter 10 of Animal Farm shows how all these original 7 commandments were wantonly abused and eventually reduced to a single commandment. Clover said to Benjamin, "My sight is failing me." She said, "Finally, even when I was young, I could not read what was written there, but it appears to me that the wall looks different. Are the 7 commandments the same as they used to be, Benjamin?" I say, for once, Benjamin consented to break his rule, and he read out to her what was written on the wall. There was nothing there now except a single commandment. It ran. All animals are equal, but some animals are more equal than others. After that, it did not seem strange when the next day the pigs who were supervising the work of the farm all carried whips in their trotters. It did not seem strange to learn that the pigs had bought themselves a wireless set and were arranging to install a telephone and had taken out a subscription to John Bull, Tidbits, and Daily Mirror. Samuel Bright Acquah sought by his ruling to reduce the 1992 Constitution to the level of a dictatorship, an authoritarian judicial autocracy in which a circuit court judge assumes the power to control the liberties of the citizen in a manner inconsistent with the Constitution and the due process of law. Intino book na judge ni koti ya wadema ruling no enende Martin Amidu WARNS book na se nyama e course wo book nim se eye mboa bi asem na ye kan wo book nim na mboa no ye mo rules so mundi rules ne so na rules na ye mo so mundi so no ni ye se aboa bi a ode ne nan mienu pe ene nam no oya omotamfo aboa bi a owo nan enan anase owo ntaban no oya damfo aboa bi eni wa wo beda e wo mpem aboa bi eni wa wo be no mensa aboa bi eni wa wo be kum aboa foforo and then amwani ni na no mo ye pe. But see, even in the book no emwa no omo ndi sa rules yi so nti do baby no rules no ba beda na ba akope a ba akono ene se emwa ni na ye pe nanso no emwa ni na no ebi mu esin right, because rules no na mbo to me ndi so nti no ni na no de ba be wie ye no no nti Martin Amidu ewie ye no o kire se Ghana ye wo constitution mu na wo ye judge na wo pese deny obi bail na enu nti wakwa kokoti a dictator. And you see, before Martin Amidu will even say this, in my breakdown I said the same thing. Say the problem I had with the judge statement or the ruling on that side, because you can't quote a dictator to tell us say democracy, no, what you say. So that's exactly what Martin Amidu is also saying. Now we are not say if the citizens of Ghana do not set restrictions for themselves, then the courts, meaning Napoleon in Animal Farm, sitting as Judge Samuel Bright Acquah, will do that for them. The suspect, Kwame Bafo, at Abronye, was brought before Judge Acquah, pursuant to Article 14 of the 1992 Constitution, and the Courts Act for pre-trial proceedings, pending the commencement of the real trial after the completion of the investigations. The suspect pleaded not guilty to the charges preferred against him. Count 1, publication of false news with intent to cause fear and panic, contrary to sections 208(1) of the Criminal Offences Act 1960, Act 29, and section 123 of the Electronic Transactions Act 2008, Act 772. Count 2, offensive conduct conducive to breaches of peace, contrary to section 207 of the Criminal Offences Act 1960, Act 29. Inti Mr. Martin Amidu etwaswa or say the presumption of innocence was thus asserted by the subject by his plea of not guilty, and the burden fell on the prosecution to prove his guilt beyond a reasonable doubt. I say Abronye the charges abono eni Acquah PM wo court. The koko PM wo court no. Abronye si wonye guilty. Inti afe atop prosecution so say prosecution improve beyond reasonable doubt. The inti Abronye oye guilty. I say the fundamental rights and freedoms guaranteed every citizen by the 1992 Constitution enjoined Judge Napoleon Acquah to presume suspect Kwame Bafo innocent and to determine whether the suspect would avail himself for trial or would interfere with the ongoing investigations in the misdemeanor cases being tried before the court. Judge Napoleon Samuel Bright Acquah had no business as a professional judge to lecture the suspects or Ghanaian citizens on their fundamental rights and their gnosis. Or say, he had no business pontification about Animal Farm and on his personal opinions that the Ghanaian society is of late polluted with insults, which, if not checked, will put the security of the nation into disrepute or open the Pandora box, for many people to also do same. It is the wish of the court that all Ghanaians should try and prevent that insults from the society. Now, Utie from where Martin Amidu is coming from. I say judge there. Wo there, enye wasem se wo betre obi asem mu. Eye prosecution e di ni case aba. Ono na wode asem ato Abronye so. Se waba na wo judge, wo there ne so betena case ne so, no we di obi asem. Grant Abronye bail. Se wo hwe na se wo grant ni bail a about wo judge no. So be hu ne se okay, Abronye ne kra no. The inti a yem money bail ne say ye money bail a womba. Into wo judge also determines idea no. But se wo din kan na wo kan say na nsenkra Ghana na atemdidi adoson dodo enu ntimi ye we a na say wo judge kra wo din kan ebu asem ne kra deda. But Abronye claim say wonye guilty. Asem we dey ato ne so no, o se wonye ye. Na won so di ka o kan sem we dia. Na say ase de wo kra no wa fa wadwen deda. Ati ase. And so he went on saying, say, Judge Napoleon Acquah, but you see, there's one thing about Martin Amidu's writing. He will bash you and mock you. He said, "What to Judge Nidin Napoleon?" Or say, Judge Napoleon Acquah, based on extrajudicial considerations inconsistent with the court's bail jurisdiction, in which the suspect is presumed innocent, found the suspect guilty of political insult and remanded him into prison custody at NIB, whatever NIB means. Judge Napoleon Acquah then, in typical Orwellian fashion, adjourned the case to 19th September 2025. The fact that Judge Napoleon Samuel Bright Acquah was using bail as a punishment, despite the suspect presumption of innocence, and the fact that Judge Napoleon Acquah had descended into the political arena between the governing NDC and opposition MPP is amply demonstrated in his conclusions when he stated as follows: that political parties should also introduce policies that will check that politics of insult and take it out of our society. So, if parties engage themselves in such acts and they cannot solve it by themselves and bring it to the court, it is the duty of the court to also play its role in wiping out that politics of insults from society. The court therefore remands the accused person into prison custody at NIB. Counsel may repeat his application on the next adjourned day, adjourned to 17th September 2025. Tutie ahase in sema woka Abronye wabakot se wo ye innocent. Na wo judge una hu say Abronye whether say unya hu evidence say whether o ye innocent and say dabi na we din kan ka ene MPP ni NDC na say mo patem didie enti se muntumi ncheke mu ho a media mo ba ha court ni ye be cheke mu na senya make na say judge we din kan bu asem de da ni ho ale pa ko say wo ye innocent. nso wa ma ruling bi say na just say wo sheda ma remand ne say o de ye den o de punish no. That's what Martin Amidu is claiming. Or see a quick search on the name Judge Samuel, a quick Google search on the name Judge Samuel Bright Acquah would disclose the consistent abuse of the rights of citizens to bail on extrajudicial grounds and as a punishment contrary to the citizens' freedom and right to be presumed innocent. As Judge Napoleon Acquah confesses in his ruling and are referenced in the Republic versus Raphael Okai, Acquah, where the suspect was alleged to have insulted the then president, Nana Addo Dankwa Akufo-Addo, he gave the suspect 2 weeks remand just to cool down tempers. Emphasis supplied. I see, uko Google now search judge ni diya. Ube mse judge ni subayano no. Inti ya hona wakoti 2023 case a judge no eche NDC ni bi 2 months because we di Akufo-Addo attempt no. I say Judge Napoleon Samuel Bright Acquah also confesses in the ruling and a reference that just about 2 or 3 weeks ago, another matter from Circuit Court 8 came before me. Republic versus Emmanuel Kwache, the journalist from Wontumi TV, and he was also remanded for same 2 weeks. The remand of these suspects, who had pleaded not guilty to allegedly insulting the president as preliminary punishment before trial, constituted a blatant abuse of the fundamental rights and freedom of the citizen and flies in the face of the hallowed grounds of exercising the discretion to refuse bail in serious cases. The fact that Judge Napoleon Samuel Bright Acquah had the impunity to inform the public of equalizing the use of his extrajudicial reasons for refusing bail in the Raphael Acquah and the Emmanuel Kwache cases makes him an opportunist seeking to please presidents to enhance his self-promotion. I say judge no. Ono ankase nyakukudro na chema Wontumi journalist ya. Ono nso yamane remand sa no. I say judge ya netina case ni so. Na judge na enyakukudro eka ewo ni ruling mu se ono na di sa case no. Na twese ono Martin Amidu do hu ne se judge no. Ase osiki favor from the president. Opeso seeking favor from the president. Right? Martin Amidu nsem wo kan no. As a judge ne peso seeking favor from the president. Eno hunti na wo yes anyama yi. Enya only this president. In fact, Akufo-Addo time krasa. It was also say the Ghana Police Service prosecutes criminal cases upon the delegated authority of the Attorney General, and the Attorney General is ultimately responsible for ensuring that police prosecutors do not consistently present sensitive cases to inferior courts of their choice, where they can always have their way because of familiarity between police prosecutors and the inferior court judges or magistrates before whom they always appear. Any lawyer with integrity who has defended suspects before inferior courts quickly learns the relationship that develops between police prosecutors and inferior court judges or magistrates. We used to recount stories about how the rapport is built when a new magistrate or circuit court judge is transferred to a new station. The police prosecutor comes to court, enters the chambers of the newly posted circuit judge or magistrate for the first time, salutes the new circuit judge or magistrate and says to him or her, "You are welcome to this district, sir. Everything here is good, sir. We look forward to working with you, sir. Hopefully, this is now a thing of the past." And you see, Martin Amidu is exposing something in our judiciary a lot of people didn't even know. I see, normally, no. Ohwe saa judges a womotina courts a ebia eye courts ketwa so a. Eya na police for because police prosecutors no. Ena edi case no ebeko court. Right? Omo no mo prosecuting on behalf of the Attorney General. Inti police for no omo the case no court no. Omo hu say judge be abba omo district for the first time, and this is not the high court, we the inferior courts. So Ghana, we have the superior court and we have the inferior court. In the inferior court, ne sa district court, ne sa magistrate court, ne sa level no. To say a hona bonene taisi. Inti police ni chi obi. No de nipa kro ne kɔ hɔ a. Police ni no any judge no enya rapport. Oma dane namfofo. Inti se judge ni hu ni say police prosecutor we the case e ba pe. Wo nipa no asem ye de say the judge no obema wa ko remand. This is what Martin Amidu is exposing. If along this I replace Martin Amidu's name with Martin Pebu Amofanchame, we are talking about Martin Amidu, the former special prosecutor. It or expose say there a tie no between the judge and the transfer judge be court be the first people on member be channel police for no ye build the rapport into police need the nasemba pe or ka say oh we there remand judge no be obeko remand sir. You see into claiming the lives of people, the freedoms of people and ye dey to chacha sa no. But adia wo kan ya me den say or say I hope this is now a thing of the past. O hope say adia we enko subium. Or say when the Attorney General cedes his prosecutorial powers to the police to investigate and prosecute citizens without further reference to him in overly sensitive cases, or encourages the police to assume such sensitive cases for purposes of deniability of responsibility by the Attorney General, he may find himself tacitly or intentionally creating matters out of suspects seeking martyrdom. One of the cardinal principles of the prosecutor is to deprive a suspect seeking martyrdom the chance to achieve his objective. I can give specific examples from during the PNDC and NDC periods when we, in the office of the Attorney General, purposely deprived suspects their desire for martyrdom. No Attorney General must allow the police and inferior courts to mess the government up with cases involving political opponents. Into otie Martin Amidu nsem oka enkrofo bi ewo ho a omo hyeda kan nsem bi so that ebe chi omo atum na dede aba kronim na omo ayo omo ho te se de omo ye heroes. Political opponents be bre wo ho asa wo pese wo kan bibi ne eba be chi no ye chi ne wi a I am a hero, I'm a hero. Inti se mu ne mo be kai a chema wuntumi the presenter ne ye chi ne na asem a wo ka no I am a hero, I'm a hero. Inti Martin Amidu nsem a wo ka ne se e wo se aban ni da ho na sa nkrofo a wo mo yesa ade ni nina no nsoso omo so omo Martin Amidu wo mo mre PNDC ene NDC mre Rollins time no na nkrofo bebre wo ho a no mo pese omo yesa omo pese omo use system no e build omo political career na nkrofo hu omo as heroes nti omo Martin Amidu omo nsoso sa nkrofo ne so nti the current Attorney General no onhwe yi aban hwe yi ni nsoso sa nkrofo ne so. Also, incarcerating persons suspected of misdemeanors and minor felonies at the National Intelligence Bureau holding cells in cases not being investigated by the NIB is abusive of the letter and spirit of the 1992 Constitution. To say, Abronye wo the case na, a misdemeanor, enye case be a son sa, enye BNI for ana NIB for ena air prosecuting a police. Now so ye de na court ye de ne court no ye say ye de na to remand onko BNI for kukum ono trese nyansa enim we never knowing allow that to happen under our watch in the Attorney General's offices when I served there cumulatively over a decade under the PNDC NDC 1, 2, and 3 governments. Please, Dr. Dominic Akrutinga Ayini. So many unpleasant things are happening under your watch within the short period you have been the Attorney General. I have for personal reasons held my guns in the hope that you will do the needful and leave behind a legacy of respect for democracy, the rule of law, and constitutionalism as the principal legal advisor to this NDC government. Judge Samuel Bright's Acquah has already done enormous damage to the image of the NDC government under your watch as the Attorney General, and nothing you do now can restore that abuse of the rights of the suspects he has denied bail on extrajudicial grounds, because your office allowed them to happen without vigilance or on grounds of partisan political vindictiveness. The foregoing examination of the ruling of Judge Samuel Bright Acquah in the case of the Republic versus Kwame Bafo at Abronye exposes the judge as a danger to the legal profession. So I say, Dr. Ayini eba bedane Attorney General nyama bebree si a wono Martin Amidu na nke wo se wakasa wo ho nanso wahye ye kom nanso osre no judge wey egu NDC aban enimu ase na Dr. Ayini won sorry. I say the judicial service as a circuit court judge, the fundamental rights and freedoms of the citizens guaranteed under the 1992 Constitution, and as a person unfit to be a judge of any circuit court in Ghana. Every reasonable and objective non-partisan reader of the ruling refusing bail in a case under discussion cannot fail to appreciate that Judge Samuel Bright Acquah does not possess the learning, integrity, and high moral character to remain on the circuit court, let alone to be elevated to the Superior Court of Judicature. The Republic of Ghana, under the 1992 Constitution, is not animal farm, in which all animals are equal, but some animals are more equal than others. I hope and pray to God that Animal Farm is not the country. It's not the country President John Dramani Mahama wants to leave for Ghana as his legacy under Superior Court justices like Samuel Bright Acquah. Mr. President, listen to the elders in the room. God save Ghana and the 1992 Constitution. Martin A.B.K. Amidu, 14th September 2025. So this is Martin Amidu. It was going to be long, but very typical of Martin Amidu. Watre na adwin wakasa. Montre mwaji wa comment box nimo. Medase.